Hi, this is David Black. Today we're talking about an evidentiary hearing. For us lawyers, it's a very easy question, what's an evidentiary hearing? But for lay people, for clients, even for some of my employees, the question really is, well, what is an evidentiary hearing? It sounds like a big word, and I don't know what happens in one. There are different types of ways that we try to keep evidence out of court. Sometimes it's because they can't establish the chain of custody, for example, for blood in a DUI case. In that event, we would make an objection. Sometimes we might do it before trial, sometimes even during trial. If we allege that there was a bigger violation, a violation of your constitutional rights, for example, an officer didn't have reasonable suspicion to pull over your vehicle. You didn't commit a traffic violation, let's say, or an officer didn't have probable cause to arrest you. He didn't have enough factors to lead him to conclude it's more likely than not that you committed the offense that you've been charged with. You could think of that as an objection too, also to the evidence, but it has to be done beforehand and it has to be done in writing. And what we as lawyers write is not evidence. So there will be an evidentiary hearing where the witnesses would come in and testify, where the witnesses would come in and testify in order to see what evidence, in fact, it is that we're talking about, how it was obtained, and whether or not it's going to come in. So the long and the short of it is that an evidentiary hearing is an opportunity outside of the view of the jury to have, say, a 30-minute to 2-hour hearing on whether or not this specific piece of evidence will come in. As always, I encourage you to ask me or your lawyer for more questions about your own case, and I thank you for viewing my blog today.